connect.
Yes, you are visible. You can go ahead, sir.
Right. Thank you. So before I begin, sir, I want to, thank you for this opportunity to allow me to come and speak over the aspects of property and registration pertaining to Methodist Church in India or other trusts that are involved. So first of all, to begin with, I thank you for providing this opportunity to me. And to everyone who's here, everyone who will be watching this video later on in a recorded manner, welcome to this early morning session about trusts and registration. Uh, Topics which are extremely relevant to us today, which have been relevant to us today, and with time and how situations are changing in the country, these laws have become even more pertinent for every member of the Methodist and even other societies and trusts at large. Now, moving back to our topic, which have been provided by Sir, which is property and registration session. Before I begin, I would like to initially talk about Methodist Church in India, our status, and our identity. So the Methodist Church in India is a trust that is registered under the Bombay Public Trust Act, 1951. Prior to its registration as a trust with the Bombay Public Trust Act, the Methodist Church in India was registered as a society in Maharashtra under Indian Societies Act. At that time, at the relevant time, this was a requirement of law for any trust to be registered, to be prior registered as a society. So subsequently, once we were registered as a society, when the Bombay Public Trust Act was promulgated, we wanted to utilize the advantages of being registered as a trust. So to which I'll be detailing out what are the advantages and why is it that it is beneficial for bodies to be registered as a trust rather than a society. We became registered as a trust with our separate registration before the Charity Commissioner Mumbai, our head office being in Mumbai. And this is the reason today Methodist Church in India has an identity as a trust and not that as a society. Since we are registered as a trust under the Bombay Public Trust Act, we are susceptible to the governance by the Charity Commissioner's office, which is Bombay. And we are also, as per law, mandated to follow all the provisions of the Book of Discipline as well as the Bombay Public Trust Act. This concept is called municipal law and civil law. So the Book of Discipline, which is our own bylaws, which are codified by us in the form of a Book of Discipline, are municipal laws for us, whereas the Bombay Public Trust Act is the civil law that is applicable universally and generically upon all of us, upon all the entire trusts. Anything which is in violation of Bombay Public Trust Act, in spite of its presence being there in the Book of Discipline, will be overread and the Bombay Public Trust Act shall prevail over the terms of Book of Discipline. Moving back to properties, its registration, how to understand its genuinity, how to go ahead and how to take all necessary precautions while acting on behalf of a trust such as Methodist Church in India. As a trust, what a trustee is entrusted with is the responsibility of the assets of the trust. This is what is the layman's definition of a trust in India is. A trust is specifically designed for a specific purpose wherein the trustees hold all the shares, all the assets of the trust, and they act in a fiduciary capacity with regards to the trust. They act in furtherance of the objectives of the trust and getting the same fulfilled. Herein, whenever a trustee, a member of the trust, either a recognized trustee or someone who has been entrusted the job on behalf of the trustee, whenever they embark upon dealing in a property, whether in order to buy a property or whether they're going to sell a property of the trust, they're governed by the laws. As I stated in the beginning, they're governed by the laws of Book of Discipline as well as Bombay Public Trust Act. So what happens herein? Let's first talk about buying a property. If a trust wants to buy a property, there are certain laws and certain regulations which are to be followed and which are to be undertaken by the trust through its trustee or through its member. Buying a property is comparatively easier than selling a property. We'll reach there in the second stage. And firstly, with regards to buying a property, whenever a member or a trustee is buying a property for a trust, the specific requirements or the precautions that have to be taken are more or less generic in nature. Even when a person is buying a private property or a private person is buying a property, these specific requirements are to be followed by them as well. Most importantly, we have to, while acting in the capacity of a trustee or a member of a trust, whenever the responsibility of buying a property is entrusted upon any specific person or a body within the trust, that body has to show due diligence. The concept of law that has to be followed is called due diligence. Due diligence in common parlance would mean adequate, um, I don't know, adequate precautions. I think if I can sum it up generically, adequate precaution would be the most appropriate manner. If a due diligence has been done, that is when the trustee or the member has completed its entrusted responsibility and under the law is allowed to go ahead and even falter. If the due diligence has not been done, if the minimum required, commonly generically applicable precaution has not been taken or has been ignored voluntarily or involuntarily by the trust through its member or trustee, then not only civil but criminal liability is imposed upon that particular member or that particular trustee. So due diligence is very important. Let's go upon what is due diligence whenever we are buying a property. Now, for a second, let's forget about Methodist Church in India. Let's forget the fact that we are acting in the capacity as a trustee or a member. Let's limit ourselves to the concept of buying a property. Whenever we go and buy a property, there are certain considerations that have to be taken into point. Most importantly, we have to ascertain the genuinity of two things. One, the seller. Two, the property itself. As far as the seller is concerned, when there's a judgment of the Bombay High Court while dealing a matter from the Charity Commissioner's office, it's a 2016 judgment. What it states is whenever a trust is buying a property, it's dealing in a property, it's having any transaction for a property. It's the responsibility of the trustees and specific officers entrusted with such work to conduct a due diligence not only upon the property or the title of the property, but also upon the owners, the parties involved. So basically, the judgment which I'm trying to discuss here, in that case, what had happened, a party had approached the trust, uh, offered to enter into a joint venture. The joint venture obviously could not succeed, because of which it ended up in the litigation before the Bombay High Court. The trust's ground was that the other party which entered into the joint venture was not able to fulfill its obligation under the joint venture. While the Bombay High Court was ascertaining whether, which of the parties had faulted, because of which the joint venture could not succeed, the Bombay High Court made a beautiful observation wherein it stated the objective of the trust will not be fulfilled by only entering into an agreement, but also more so because a trustee or a member is in a fiduciary capacity and is actually responsible for the assets of the trust. They have to conduct due diligence upon the party. It was an obligation upon the trustees in that case before the Bombay High Court. It was an obligation upon the trustees to conduct due diligence upon the party that they are entering into an agreement with. How do we conduct this due diligence? In that particular case, it was a business entity. So what the Bombay High Court stated was that they should have conducted the minimum required due diligence either through a chartered accountant's office or through a legal attorney's office, and inquire into the past assets or the past allocation of funds within the company and outside the company to understand whether it has the financial capacity to enter into an agreement or not. Number two, the court stated that whenever a trust is entering into an agreement with a party, it is mandatory upon the trustees or the members representing the said trust to also conduct a due diligence upon the legal probabilities of the company. Just like we are a trust, just like Methodist Church in India is a trust, and according to our bylaws, it's only the position of General Secretary sitting in Bombay who is entrusted with the rights to either purchase or dispose of any movable and immovable property for the Trust Methodist Church in India. Similarly, every company or every entity, be it in the form of a society, in the form of a trust or a company registered, even a private man for that matter, it may have a specific provision with regards to who is entitled within such organization to enter into an agreement. So, in case we are dealing with a body, in case we are dealing with a society, in case we are dealing with a trust in the form of an NGO, non-NGO, any body, not a private person. First and foremost, what we have to understand is the person who is representing the particular body in front of us, whether they are actually authorized as per the bylaws governing the said body to come and enter into a legally binding agreement or contract with us as a trust. In case we are dealing with a private party, what we are supposed to do is we are supposed to do a due diligence upon the financials of that private party through his duly filed ITRs, through his duly filed records that are there available with the government department in order to ascertain whether the party is financially capable of fulfilling all the obligations that it is willing to undertake in any form of agreement while it is entering with the trust. When we are buying a property, these things are not that difficult in order to understand, because financial obligation, the financial capacity of the seller is not something that we are concerned with. But at the same time, we have to ascertain or we have to conduct a due diligence about regarding the property in question. We have to make sure that the property and its paper and everything is clear. Now, how do we do that? There's a very specific provision made recently, somewhere around 22 years back, with regards to purchasing of a property, which is obtaining of OC. Whenever all over the country, the government of India has provided a service, started a service of encumbrance certificate. Whenever you're dealing with a property, insist upon the encumbrance certificate from the particular party who's trying to sell you the land or the building or any form of immovable asset. An encumbrance certificate is a certificate provided by the government department wherein they state whether the property in question has any legal hassle, has any legal proceedings pending upon it, has any right or title or claim pending against the owner. What it states is, what it clarifies is, if there is any legal encumbrance upon the property, the encumbrance certificate will have its mention. So one way to begin with is to get a encumbrance certificate from a due authorized government agency. Number two is a generic law which is specifically applicable more stringently upon trusts like Methodist Church in India and other trusts. No property that we purchase can be purchased for lesser than the circle price. Now, properties have two values. One is the circle price, which is also called the government value, which is also called the ready reckoner's rate, depending upon state to state. And the second is the market price, which is the ultimate purchase price or the deal price. Any property that is being purchased has to be purchased above the ready reckoner's price, the state price, whatever we call it in our own language, in our own states, but it has to be registered at a price above that. What happens when you register a property undervaluing it or below such price is these are susceptible to inquiries by either the income tax department or the revenue department, depending upon how big the transaction is, which as a trust, Methodist Church in India or any other trust would like to avoid. The property registration on the transaction always has to be above the circle rate, above the ready reckoner's rate, in order to avoid the unnecessary scrutiny of such bodies. Number two, once the prices have been agreed to be above the ready reckoner's rate, we have to move ahead and get into the specific title requirements. As I said, an encumbrance certificate is a good place to begin with. It has to be followed with ascertaining whether the title deeds that have been provided or being shown to us by the party that is selling the land or the property to us are genuine or not. So we have to approach the district collector's office or the tehsildar's office or the MM's office, again, depending upon different districts. Different states in India and different districts in India have uh, different bodies which have been made responsible for this, depending upon the size of the population and all. So whosoever is the authorized government agency in any particular district is supposed to provide you with the details. We as trustees or members are required to go to such bodies, ascertain whether the title that is being provided to us by the seller are genuine or not. Once there's a proper application in all these places, again, depending upon which area you are, the specific act or the specific provision would change, but the generic law is these bodies are required to furnish upon an application by ourselves to furnish to us a proper, legitimate, and stamped uh, title of the property that we have filed an application for. Once we have done this, and once we have completed the due diligence with regards to the property, we will be clear to go ahead and buy the property. But these basic requirements, both about the circle price, so that the transaction is above the circle price, as well as the due diligence upon the title of the property, is mandatory upon all of us. It's something that we have to follow, which in case we do not, and tomorrow it leads to some kind of a legal hassle, the trustee or member who has represented and gone ahead and entered into a transaction on behalf of the trust will be personally liable for that. Moving on to selling a property. What if the trust is selling a property? How do we inculcate all this required due diligence? Whenever the trust is selling a property, number one, the financial due diligence, which I talked about, the transaction being above the circle rate, that remains the same. There is no change in that. We have to do the due diligence. We have to sell the property at a price that is above the circle rate. The selling price cannot be below the ready reckoner's rate. Number two, due diligence upon the party who's buying. This becomes much more applicable in cases when we are selling the land. If a party approaches us and shows its inclination to buy a land, as per the Bombay High Court judgment, which today is undisputed and has become the law of the land, it is mandatory upon the trustees and members to do a due diligence upon the financial capacity of the individual person or the body concerned that is dealing with the trust, in order to ascertain whether the promises that are being made by such body, such person, are possible to be fulfilled or not. In case a trust like Methodist Church in India enters into an agreement or a joint collaboration with one of these parties and have not done the due diligence of financial scrutiny of the other side, and it leads to a legal hassle, again, the members who were representing the trust in such dealing will be personally liable for this. Right. The next topic that I've been asked to discuss upon is the difference between a trust and society and how to register such bodies. The primary difference between a trust and society, not going too much into the legal nitty-gritties, the primary difference between a trust and society is a trust is a specific body wherein okay. So a trust is a living body. It has its own assets. It has its own obligations. It has it's governed by its own bylaws, wherein the objectives are the primary purpose to be achieved. Whereas a society is a collection of person. It need not be holding any assets. It need not be following any objective. It need not be fulfilling any such requirement that are obligated under a trust in order to be recognized as a trust. The reason Methodist Church in India is registered as a trust, or the reason it is easier to govern yourself and to administer a trust in within the country in India legally, is a trustee is provided all the power to ascertain and administer and utilize the assets of the trust in furtherance of its objectives, subject to any condition or permission required through the Bombay Public Trust Act in our case, whereas in Indian Trust Act all over the country, or any other specific trust act applicable within specific states. Whereas in a society, there's a central law called Indian Societies Act, which simply provides a society could be formed even by 5 people who are just to give you people an example. If there's a group of people which is interested in night watching, stargazing, night watching, they can form themselves a society, register themselves as a society only on the basis of their hobby or interest in night watching. Whereas a trust, in order to be registered as one, has to have assets, has to have objectives. The requirement of registering a trust is much more difficult at a much higher pedestal than compared to registering a society. All you need to register a society is a body of people, which is more than three, to come together for a common objective and recognize themselves as a society. Whereas a trust to be registered has multiple requirements under law, most of which are generic in nature. Few are different in kind, depending upon which state, again, where we are trying to register the trust, which area, which specific law is governing us in that particular area. But the requirements to register a trust are much more stringent and at a much higher pedestal in law in comparison to a society. Now, once a trust has been registered, the administering of a trust is much more easier. The minute a society has assets, it becomes very difficult to administer a society under the Indian Societies Act. But once a trust has been registered, once you have succeeded in registering a trust by following all the required mandated laws, administering a trust is comparatively much more easier. You're only subjected to a supreme authority, either in the form of a charity commissioner, or also called joint commissioner in different state, or also known as the joint commission holder in different states. So it entirely depends upon which area we are dealing with. Moving ahead, just give me a second. Yes. Moving ahead, we have been told to discuss with regards to NGOs, how to register schools, NGOs, colleges. Now, again, these are requirements which are specific, area specific in law. There's no generic law governing all over the country. There's no central law, so as to speak, which is applicable for registration of an NGO or a school or a college all over the country. The laws may be generic in nature, but they're codified as separate laws under different states. These are all state subjects and not a national, not a central subject. The generic applicable laws, whether with regards to registration of an NGO or a school or a college. Now, before I begin, an NGO is a non-government organization. It can be in the form of a trust, it can be in the form of a society, it can have any form. Whenever the objective of the trust or society is not to raise money, is not to create profit, it's in the form of a non-government organization, NGO. The advantage of registering oneself as an NGO is, again, the laws governing you are not that stringent. You are not mandated to have audited accounts. You're not mandated to have uh, a chartered accountant or a CFA, depending upon the turnover or the assets that the body has. So the requirements are much lenient in nature. The functioning is much more easier for an NGO. The only mandatory requirement being the books of account in the society or the trust, whichever has been registered as an NGO, shall not show any private profiteering. That profiteering aspect cannot be included whenever you're dealing with an NGO. Methodist Church in India, for that matter, is a minority religious trust. We are not an NGO per se. We are a minority religious trust. Other trusts or societies which are registered in an NGO, it's come to think of it, NGOs in generic are very small bodies. They're not as big as a trust or a society. Trust or a society, so let me put it this way. Every NGO is either a trust or society, but not every trust or society is an NGO. A body that becomes big enough, it becomes difficult for them to continue as an NGO. The bigger it becomes, the smaller a body is, both financially and as far as the size is concerned. It's easier for them to continue operating as an NGO. There are bigger NGOs, there are humongous NGOs, for examples, but their functioning and their compliance of law becomes more and more difficult with the growth in their size, the growth in their volume, and the growth in their financials. Registering of schools and colleges. As I stated, these are state governed subjects. These are specific to states. If we move on to Karnataka, Karnataka has Karnataka Education Act governing both the running, establishing, registering of any education institution within the whole state of Karnataka. What is mandated upon us while registering a school and college is provided in such state laws. Beyond a lot of procedural aspects that has to be followed and that has to be complied with before we can be registered as a education institution, either a school, college, either NGO or non-NGO, there are few generic provisions that are applicable all over the country, be it Karnataka, be it Goa, and every other state. Those generic provisions with regards to all registration of schools, registration of colleges, registration of an NGO are as follows, which I'm providing. First and foremost, whenever you're thinking of registering an education institution, what is required under law, what is required to be provided to the specific body. Yes, sorry, there's some network issue here because of which I was disconnected. Okay. Going back to the generic provisions that are required for registration of a school or any education institution in India, beyond the specific state imposed regulations, which may be not generic in nature, which may be specific to a particular state. So we'll talk about the generic provisions that have to be there. Number one is you have to be registered as either as a trust or a society. Private people also have schools, individual bodies also have schools, but the requirements in law have changed over time. Today in India, it's much more easier to initiate an education institution if you are registered as a trust or a society. Because for the government, it's easier to govern a body of trust or a society compared to a private individual. So, certificate of registration, number one, is the first primary requirement. Once you have decided to register yourself as an education institution, make a decision whether it's going to be in the form of a society or a trust. Again, both have their own advantages, both have their own ease into registration, vis-a-vis ease of running. So once that evaluation has been done, kindly produce your certificate of registration. Once that certificate of registration has been obtained by yourself, it has to be submitted at the requisite government office. It can be in the form of an SDM or a Tehsildar, as I stated. And that is how you begin the process. That's the first step. Once that has been recognized, once that has been accepted by such body, be it a Tehsildar or an SDM, a certificate of recognition is issued by the same body, which provides that yes, the certificate is filed by you, the certificate submitted by you along with your application is duly recognized under law, and this certificate of recognition becomes a certifying certificate for your life, for your identity, be it in the form of society or a trust. Now, moving ahead, once you have filed an application and once the requisite permission has been provided by the SDM or Tehsildar or the government body, local government body, what is required is for you to decide upon a certificate of affiliation. Once you have the infrastructure there, once you have shown an inclination that here is the building, here is where I want to start my education institution, and the government has given you a certificate of recognition that yes, we recognize your plan and we recognize the fact that you're a trust or society which is intending to initiate such education institution. There's a certificate of affiliation that is required, so you have to decide and make a decision with regards to where, with which board, with which body. There are multiple bodies, operating within India today. Which body, whether at the level of schooling or at the level of college, are you ready to associate yourself? Are you ready to inculcate in your education institution? These all bodies, be it CBSE, ICSE, state-run bodies, international boards, these are all again very varied bodies. Uh, the crux may be the same, the teaching may be the same, but very separately governed bodies. The stringent requirements of these bodies are very different from each other. The timetables are different. Each of them are different. So again, the trust has to take a common decision. The syllabus is different. The subjects are different. So the trust, Methodist Church in India, our pastors will have to take a decision at this specific time. Which body of affiliation would they want to go ahead and get themselves accredited with? And once that accreditation is done, I'll say the paperwork is more or less finished. Then the physical work, physical side of establishing the education institution starts, which is the creating of infrastructure, setting up the whole building, all required furniture. Once that part is done, there are multiple certificates or permissions that will have to be obtained from the government department, both in the form of safety, such as fire certificate, such as safety certificate, and also in the form of children, since you'll be having children to study. So there'll be a lot of requirements which are state governed, which are mandated by states, which all those permissions will have to be required. Once everything is done, there's an NOC provided by the government, no objection certificate. And that will only be provided once you have fulfilled all other obligations and requirements. And the sooner you have the NOC with you after you've fulfilled all obligations, the sooner you can begin with the entire education institution. Okay, I am hoping I answered this point. Just give me a second. Moving on to okay, just one more thing before I begin. We as a Methodist Church in India, talking specifically as Methodist Church in India, Methodist Church in India is being a minority religious trust. We have a fundamental right. It has been recognized by the Supreme Court in India through its Constitution Bench judgment that a minority religious trust has a fundamental right of establishing a minority trust per se, of establishing and administering any education institution without any hindrance or unnecessary regulations by the state. Giving an example, a Muslim minority body, be it in the form of a trust or a society, is allowed to create, to establish, and to administer an education institution, be it in the form of a madrasa, and it cannot be governed by a state law. The state cannot mandate what is to be taught there. The state cannot mandate how they employ their employees, how they, both taking them on board as well as asking them to move out is not governed by state laws. This form of independence is provided to a minority religious, a minority trust per se, minority body, be it in a minority society or a minority trust. This is provided to a body which is minority in nature with the purpose of furtherance of such minority education. That is the purpose of the law. That in case a minority body, as far as Methodist Church in India is concerned, we're a Christian body. We belong to a religious minority sector. So if we want to propel education, we will not be required to follow all the government norms and all the government dictions which a non-minority body will be required. Our establishing and our ways of running will be different. I'll give an example which may be relevant and which may be easier for all of you to relate. If you see any education institution within the Methodist Church of India, uh, in the past, even now for that matter, a lot of appointees that are there, which are either working or are appointed in any capacity within such education institutions, are family members of people who are already there. So there are multiple examples wherein the teachers will be related to each other in one form or other. And this relation is what is the required qualification for them to have been employed by us. Now, Karnataka Education Act for that matter, or any state education act for that matter, has very specific requirements, stringent laws for employment of teachers, which is not governing us. So we have a freedom to employ anyone, we have a freedom to retrench anyone, and utilizing that freedom. Today, the staff base that we have at our education institutions can be found to contain multiple groups of people belonging to the same family, either immediate family or extended family, because we are not governed under such specific laws, specific requirement, and employment within our education institutions, a minority education institution, is an absolute state independent act. We are not governed by any provisions of law as far as employment is concerned. Once the basic requirements have been followed, the basic requirement being the Supreme Court has mandated that employment of a teacher or a staff at an education institution shall be for furtherance of the education. It shall not deter from the objective of providing education to the kids. Once this basic requirement is fulfilled, there's no other specific requirement about with regards to the education qualification or with regards to the number of years of experience associated with a particular post that has to be mandatorily followed by us. It's good to follow it, but yeah, we are not mandated to follow it. Okay. One more topic I have here is at the time of handling over, what are the to the next committee, what are the matters of registration and property which are to be handed over? So whenever trustees retire, the retirement of trustees or members of a trust are provided in the bylaws of the trust, for which in our case is the Book of Discipline. So whenever the trustees retire, be it our bishops or be it our general secretary, anyone who's occupying such ex post facto post, under law, they're required to hand over all the documents pertaining to any body, any property belonging to the trust, which was vested in them in their capacity as a member of the trust or a trustee. Withholding of any such document by such members or trustees would disqualify them and also impose a criminal and civil obligation upon them. The new trustees and new members can claim damages upon such past members who have passed or who have retired. Also, in case that tomorrow the trust finds itself in any legal proceedings, any murky legal proceedings, the trust has the right to initiate criminal proceedings upon such members, either in the form of white collar crimes such as forgery, cheating, depending upon case to case, facts of each case. But yes, uh, such members and trustees who have not completely dwelled upon or not completely handed over all the required documents, titles, anything that they had in their capacity as a trust member, as a trustee, are both civilly and criminally liable at a later stage by the new trust members. So, what is it that we should see at the time of taking over? If we are taking over and the position of a trustee or a member, okay, let's do this with an example, it'll be easier. The General Secretary's position in the Methodist Church in India. The General Secretary is a licensing officer. The General Secretary is the sole custodian of all assets in Methodist Church in India. So whenever a new General Secretary is taking over, a new General Secretary is stepping into the same office, it is mandatory upon the new General Secretary, both old and new, that all the documents pertaining to all the properties, movable and immovable, changes hands. The outgoing General Secretary is mandated under law to provide a list of all the properties and all the documents that is present at at their office. Under law, as I stated, it's mandatory upon them to hand over everything. They cannot withhold any document, they cannot withhold any data. At the same time, the incoming General Secretary, it is mandated upon them to make sure to ensure that whatever handling over is required, all the documents, all the data has actually been handled over. Again, the operative word here is due diligence. If the minimum requirement, minimum precaution has been taken by the incoming General Secretary at the time of assuming the charge of the office, then tomorrow, in case few documents were not handed over to him, few documents or few titles were not provided to him, can be utilized by him as an excuse, as a legal excuse to avoid any legal repercussions. But in case such due diligence has not been undertaken by the incoming General Secretary, then the liability, either civil or criminal in nature, will be bound to both the old and the new General Secretary, more so the new General Secretary. To give a legal example in order to understand this better, if there's a joint venture that has been entered by Mr. A, Mr. A is the General Secretary of Methodist Church in India. That joint venture has certain obligations upon the parties which are time barred. They have to be, they initiate at a certain stage and they have to be fulfilled by before the completion of another stage. During the term of the joint venture, Mr. A retires as the General Secretary of Methodist Church in India and Mr. B assumes the position. Now, Mr. B, under law, tomorrow, in case a joint venture goes bad and the trust is at fault, the trust has not followed the terms of the joint venture, Mr. B cannot claim excuse. Mr. B cannot say, I was not the one who signed it. I'm not the signatory to the joint venture. I am not aware of the terms at the time of me assuming the role of the office. I was not provided with this joint venture. No, this will not be a valid excuse in law. Ignorance is not an excuse in law. That's the first rule of law. We cannot claim ignorance to avoid legal repercussions or legal consequences. Mr. B, who has come into the position of General Secretary, is under law mandated to know that this is a joint venture. And in case they have the knowledge of the joint venture, then they are required to take charge of any paper, any data that may be available with Mr. A. And in case such data is not available, they have to make an official record, take a signature of Mr. A stating that these documents, which as per my knowledge should have been present with your office or yourself, have not been handed over to me. And it is still the obligation of Mr. A, in spite of the fact that they have retired and gone away, it's still the obligation upon Mr. A to collect those papers, to hand over those papers to Mr. B so that the handing over is duly done, has been done properly, has been done, the entire requirement has been followed. Okay, I'll move back to the topic of difference between a trust and a society. I think I did not dwell upon this in much detail. So I'll move back to this topic of difference between a trust and a society. And which are easier to register or easier to function. So as I said, these are state specific acts. Um, Multiple provisions are state mandated. Every state has their own requirements. But in general, generic law, there's a central law that is governing both trusts and societies. In case of trust, it's the Indian Trust Act, 1882, actually, if I remember correctly, registered in 1882. And in case it's a society, there's a Indian Societies Act, which is registered Indian Societies Act 1860. These are the two governing laws which are applicable all over the country. So states which do not have specific provisions governing the trust or society are governed by the provisions of these two generic acts. These serve as model acts for the states also. So they import all their provisions from these acts and inculcate any specific area specific or government specific provision in case they want to. Moving beyond, what is the primary difference or generic difference between the two? A trust can be formed by two members, whereas a society in general has a requirement of seven. Again, area specific, it can be more or less, but a trust can be formed by two people all over the country. Two people can come together, declare themselves to be a trustee, and form a trust. A society will require the minimum requirement is more. Okay. A trust is, as I stated in the beginning, a trust is required to have an objective. There has to be a purpose. There has to be an end to be met. A trust cannot be only, as I stated, that a trust cannot be only for a hobby or for an act. There has to be an objective for a trust to be met, which because of which there's a trust deed, wherein the objectives of the trust, the purposes of the trust are duly enunciated, are duly recorded. Whereas in case of a society, there is no such requirement. Let me see in case there's any other topic that I have not completed. I think I'm more or less touched on every topic. One more thing. The functioning of a trust, as I stated in the beginning also, the functioning of a trust is much more easier. So a trustee, say a trust is duly registered and has a group of two trustees or five trustees or one trustee even. The trustee has absolute sole discretion over the functioning of the trust, subject to the laws governing. There's an absolute discretion. They can utilize their discretion in any manner whatsoever. There's not much legal embargo upon a trust. Whereas a society works in the form of a democracy. It's an association of people coming together. So they have to uniformly come to a decision. Resolutions have to be passed, and all of them have to agree. And you have to follow as per the provisions of Indian Societies Act. There has to be a majority in order to follow, pass a resolution, any change, any amendment, which is not the case in a trust. In a trust, unlimited powers can be vested with the trustees. They can be the decision makers for the functioning of the trust, for going ahead with the trust, and there's not much restriction upon them. Same thing I'll say with the finances also. The finances of a trust, and these are all subject to the laws governing. The finances of a trust are entirely in the hands of a trustees. There's no control or there's no mandatory regime to be followed by the trustees for utilizing of such assets, as far as as far as the acts are within law and due diligence has been done. But again, not so generic or so easy as far as the society is concerned. It's much more difficult. As I said, resolutions have to be passed. A single body cannot be a signatory. Yes. So in a bank, in a trust, a single person can be a signatory, either your treasurer or anyone that you have as per your bylaws, which in our case is our treasurer. A society cannot have a single person as a signatory. A society has to have more than one, two position holders or three position holders have to be there who are signatories. So basically, the realms of the reins of a society is never entrusted upon a single member. It's always divided among the society members. Whereas in case of a trust, depending upon the bylaws that is governing the trust, the entire control, financial as well as administrative control of a trust can be vested with one particular individual, one particular trustee. These, I think, are more or less the generic differences between a trust and society. Again, these are conditioned to subject to any further differences as mandated by laws, state governing laws. Before I end this session, I would just like to go back to Methodist Church in India. I've been made to understand that it's mostly our members, all MCI members, who are going to be uh, either watching it right now or watching it at a later stage. So I would just go back to Methodist Church in India, our registration, our specific rules, and what are the due diligence aspects that are required to be followed by our pastors while dealing with properties. So as I stated in the beginning, Methodist Church in India is a trust registered under the Bombay Public Trust Act 1951. Our registration number is F405 before the Office of Honorable Charity Commissioner, Mumbai. We are governed by the Bombay Public Trust Act 1950. Our bylaws are codified as Book of Discipline, which again is mandatory in nature. It has to be followed within the trust. Whenever if we go by the provisions of Book of Discipline, as I stated, the licensing officer or the custodian of all other assets is the general secretary. So every property paper, everything is to be governed, defended in law, represented in law from the general secretary's office. And further going through the same chain, the general secretary has deputies in every state conference who are known as executive secretaries. Any property that is there which has to be defended legally or has to be defended administratively before the government can only be represented by the general secretary, and the power further being vested down to executive secretaries in specific conferences. No other person is legally allowed to represent in any such dispute. In case it's a case pending before the court, that is a legal representation, or it's an administrative representation before the SDM or anyone else. No other member, no other pastor, no other member or trustee of the society has the right to represent our trust before such body or such legal establishment. It's only the general secretary, and through general secretary, the executive secretary, who has such powers. Um, Only the general secretary can further divulge such powers. The executive secretary cannot. So, general secretary has been provided with the power to divulge his power. For example, if there's a case going on in Bangalore Regional Conference, any district within the Bangalore Regional Conference, the general secretary cannot be expected to be present at all such legal proceedings whenever there's a requirement. So the general secretary has a power to divulge his powers of representation for that particular property, either upon the district superintendent or a particular pastor or anyone. Basically, the power of divulging is there with the general secretary, but the same power of divulging is not enjoyed by the executive secretary. The executive secretary has no such power. Whatever powers are there with the executive secretary as a subordinate of general secretary are already entrusted from the general secretary's office to executive secretary. So there's no further subletting, so as to say, allowed herein. The executive secretary cannot further transfer this on to someone else. Now, selling of properties. And now we are not talking about law, we are talking about book of discipline here. Selling of properties. The book of discipline has specific provisions which govern selling of property. There are proper provisions, a proper procedure has been provided, wherein multiple bodies which are set up within our trust, be it in the form of regional executive board, be it in the form of sale and development committee at the conference level, be it in the form of executive board, executive council, managing committee. All these bodies are required to give you due permissions depending upon the value of the whole transaction. there is a proper procedure within the Book of Discipline, and also on the basis of resolutions passed by such bodies, which has to be followed. No sale can be allowed by anyone where until unless such due procedure has not been followed. If the due procedure has not been followed, then the person doing the sale, be it done by the book by Mr. A, General Secretary, or be it done illegally by the district superintendent or a pastor or any other member, that sale becomes void. It's not a sale that is binding upon the trust. The trust tomorrow can take a stand and say that no, I do not recognize the sale which has been done by my own member or my own trustee, because it's in violation. It has not followed all the mandatory requirements that are enunciated within the Book of Discipline. In Book of Discipline, it is required upon us to follow a chain of command. A resolution has to be passed by the regional executive board. The same has to be recommended to the central board, that is either the executive board or executive council or managing committee, by the executive secretary of the conference. Once a resolution has been referred to such central body, they have to, after adjudication upon the same, after understanding upon the same, they have to pass or reject such application. In case they pass it, they have a right to impose further conditions upon it or further requirements upon it. Once all these bodies have passed, the highest body being the managing committee within the Methodist Church in India, once the managing committee has passed such resolution, it authorizes the general secretary to go and execute such deed, such document, such instrument with regards to any property. Until unless the managing committee has passed that resolution duly authorizing the general secretary, Mr. A, to enter into such legally binding agreement, no agreement executed on behalf of the trust is binding upon the trust. Just to give an example, if tomorrow a member of the trust, it can be in any capacity, enters into an agreement in the form of a sale or a purchase of property, and the due procedure has not been followed, the trust or the new trustees or the new members who subsequently get to have knowledge about such transaction can state or can wash away their hands from any obligations created under such agreement, stating that the due procedure was not followed and the same is not binding upon the trust. Let me just see if there's anything else that I can relate with Book of Discipline. I think I've covered more or less these topics as far as the property and its registration is concerned, except certainly the state-specific laws which may be applicable district-wise or area-wise. And yeah, so thank you, David, sir. Thank you so much for providing me with this opportunity. I hope I have tried to tackle the areas that were, so graciously provided by you for me to look into and for me to talk over. And if there's anything that I have missed, anything that I've not been able to throw much light on or provide much clarity upon, please just inform me. I would come back and I would just, provide any further dwelling that I could with regards to those specific areas of law. So again, thank you everyone. Very good morning to all of you, and I wish you all a very productive week ahead. Thank you. Thank you.